Thanks for joining my 14th in my Arbitration Boot Camp series. I can hardly believe it. I started in 2022. Thanks to those of you who have joined me today, even though I rescheduled last week. I had a traffic snafu, so I appreciate all the well wishes I got from people asking me how I was doing. It was just a bad delay, so I decided the best course of action was to reschedule. You can catch up on my previous 13 sessions from Arbitration Boot Camp on YouTube. After this session, I will send you a recording of this webinar, links to all of the resources that I refer to, and a list of all my previous bootcamp seminars, which are also posted on YouTube. I realized that I was starting to lose track of them. It might be useful if you're finding these helpful to see a list of the previous sessions that I've done. The purpose of these webinars, of course, is to provide practical guidance on issues we all hear about, but sometimes on a theoretical or general principle level. So I hope they're helpful to you, whether you're counsel or an arbitrator. If you haven't joined before, then let me introduce myself. I will first have you out of this session today in an hour, I promise. I usually spend about 45 minutes on my remarks, and I'll look for questions at the end, which you can place in the Q&A box. Although if you've got questions, and I notice your questions throughout the webinar, I can try to answer them. I am a partner at Lerners. I'm also a roster arbitrator with Arbitration Matters, and I am the editor and a writer for my blog, Arbitration Matters, which is found at www.arbitrationmatters.com. Nice and easy. It has up-to-date cases as they are released across the country on issues relating to arbitration, with some commentary, either by me or I've got 14 other well-known arbitrators across Canada, counsel across Canada, who also provide commentary. And if you're a subscriber for free, you can get those cases delivered to your email inbox every 2 weeks. Today's session will cover what are the differences between ad hoc and institutional arbitration, when you should choose one or the other. And although in my summary of today's session, I promised to talk about which was better, which one was better than the other, you'll find as I talk about these things that the answer is, like many things, it depends on what you're looking for. The idea that one is better than the other, and there are some arbitrators who and counsel have preference for them, but hopefully today I'll persuade you to do an analysis that allows you to make a determination about what makes sense for your case. Both work for domestic or international arbitration, simple or complex matters, large or small value matters. So it's really all about the process that you want. It's helpful to define your terms. What is an institutional arbitration? Well, let's start first of all with the institution part of it. There are a number of institutions which you have probably heard about. The ICC, International Chamber of Commerce, ICDR, International Center for Dispute Resolution, which is the international branch of the American Arbitration Association, sometimes known as the AAA, the LCIA, the London, England, Center of International Arbitration, and then there are a couple of Canadian institutions, ADRIC, ADR Institute of Canada, and VANIAC, Vancouver International Arbitration Center. And I am going to be using the acronyms as I go through these remarks, so hopefully you can follow them. Institutions are, for the most part, used mostly in international arbitration, and I'll explain to you why that is the case in a moment. And you will also see domestic arbitration, ad hoc arbitration, most often used in Canadian arbitration proceedings, and I'll explain the reason for that in a moment. But that does not necessarily follow that it has to be the case. So what does the institution do? It provides procedural rules which have the benefit of a consistent, known procedure. It also provides for some kind of administration by the institution. And what that administration is differs vastly depending upon the institution. Some institutions offer less service, less administration than others, and some provide quite a lot. Sometimes you can pick and choose what services you like, and sometimes you have to take all services on offer. They invariably provide for arbitrator appointment if the parties cannot agree, which of course has the benefit of avoiding the delay and loss of confidentiality of having to seek an appointment with the court, from the court. The institution will also hold and disperse funds, which can be useful. And the ICC in particular is distinguished from the other institutions by its service in providing scrutiny of the award before it's released to the parties. And what that means is that the ICC reviews the award to ensure consistency in the analysis, typos, logic, math, make sure the math is correct. It is not there to change the substance of the decision, but it is essentially a quality control mechanism, and it's marketed to enhance the likelihood that the award will be enforced because it will meet certain procedural requirements or certain form and content requirements. And this can actually be quite important when you're looking to enforce an award internationally. The rules may offer the opportunity to have an appeal tribunal, which means that if the parties wish to appeal, they need not go to the court. Obviously, there may be confidentiality reasons which drive that decision. Each service, of course, has a cost, and I'll go into that in a moment. But institutional arbitration may be more useful where either the parties don't get along because the process is there, or because the seat is not arbitration friendly. And that means that the rules and the administration provide a full solution with less recourse to the courts. That means that the process is essentially the service that's required and on offer. And by ensuring a fair process, the idea is that you can, and a standardized process, that you can minimize recourse to the courts, particularly where there's a concern that the seat of the arbitration is not a friendly jurisdiction. Ad hoc arbitration, therefore, is simply non-institutional arbitration. It provides, in comparison, complete flexibility to the parties or to the arbitrator on determining the process. So it depends in large part upon the extent of party cooperation, works more smoothly if that's the case. And sometimes when that isn't the case, having an experienced arbitrator will make all the difference. Somebody who can bring the what otherwise might be chaos into order. The parties may choose certain rules, even if they're not actually wanting administration, which gives some structure to the proceeding. But some rules do not allow this. It can also give jurisdiction to the arbitrator to decide jurisdiction. If this is an ad hoc procedure and the parties have not chosen rules, they may simply turn over the decision-making on process to the arbitrator. And for those who are not familiar with arbitration and don't commonly practice it, this can be a fairly scary idea, both for counsel and for parties, but it's more common than you think. And it actually can provide for a very effective and efficient process. And I'll talk about that in a moment. Because I've told you that even in an ad hoc arbitration, parties may choose rules or the arbitrator might choose rules, I think you get a sense that these are not watertight compartments. And again, this gives parties and counsel and the arbitrator in some cases quite a lot of flexibility to choose what works for that dispute. Sometimes an arbitration agreement may specify only that the institution is to serve as the appointing authority, but otherwise the institution is not to administer the dispute. And again, that's permitted only when the rules allow it. You may have to go all in, or you may not have to do that. And the reasons why ad hoc arbitration is more commonly used in domestic arbitration is, of course, familiarity. The parties and the counsel are likely to come from the same background. The common law in Ontario, in Canada, is very similar, and likewise we've got Quebec has its own law which parties and counsel will understand, as opposed to parties and counsel coming from very different legal traditions. And so domestic arbitration allows the parties to have maximum flexibility, but without the risk that they come to the arbitration with completely different expectations about, for example, what evidence should be adduced and how, what the process should look like, what kinds of conduct is permitted on the part of their counsel, for example, whether interviewing witnesses ahead of their testimony is permitted. Those sorts of things can be very important, because if you don't get them right, they can undermine the confidence that the parties have in the process. Domestic ad hoc arbitration doesn't suffer from that flaw, because most of the parties and counsel come to the arbitration with the same set of expectations on what it should look like. Whereas in international arbitration, if they come from different legal traditions and have different expectations as to process, it may be that there are parties who feel a sense of unfairness or a lack of control over what's happening. And the comfort that the rules or the institutional administration provide is important for ensuring that the parties have confidence in the process. I mean, that's really what arbitration is designed to do, to ensure that even though the parties are going outside the court process, they have the same expectation of fairness. Both ad hoc and international arbitrations will result in awards that are enforceable, assuming the form requirements are met. So the New York Convention, for example, does not distinguish between awards that arise as a result of an ad hoc or an institutional arbitration. So how is a choice made about whether you as counsel or a party would like to choose domestic or international or institutional arbitration? It's something that can be dealt with very early on in the arbitration clause, and many institutions provide model clauses. The alternative is that this decision is made after the parties have a dispute, when they understand more about what the parameters of that dispute are, or the arbitration can order the process without administration, again, if the institution allows it. So the choice can be made at various points in time, but not all institutions are like. And so it's absolutely critical that you understand, if you're going to choose an institution, what rules apply and what processes apply. And that sounds like an obvious proposition, but I think when I go through the differences among the various institutions, you'll be quite surprised at how different they can be. And so it's really important to do a compare and contrast at whatever stage of the process you're at, to ensure that the rules or the actual services provided by the institution will serve the needs of your client. And some of that means, what is your client prepared to pay in the way of costs? More services means more costs. And some of the institutions provide quite a lot of service and therefore are quite costly. So understand what you're getting into. It's hard to make a list of the pros and cons between ad hoc and institutional arbitration, because one party's pro is another party's con. So I've kind of blended them in these remarks to talk about their differences. And you may find, depending upon the matter that you're considering, that some of these factors are good or bad. And many of the things that you consider to be bad for a particular dispute can be resolved by a good arbitration clause. And again, these model clauses can be very helpful. For example, if you do not want to have a process that allows for interim measures, what we call injunctions in litigation, your arbitration clause can say that that kind of provision is not permitted, or that an ex parte interim measure is not permitted. So that is how you can make some choices depending upon what you want, even if you choose certain rules. And as I've said before, some rules will allow you to opt out of some provisions and some won't. So what is the real benefit of ad hoc arbitration? And the primary benefit is flexibility. The counsel and arbitrators who are experienced, particularly in the process and in the arbitrator that has been appointed, will find this kind of a process can be used to achieve greater efficiency and a faster outcome, because they understand that the process can be designed to achieve the objectives that are necessary in that specific arbitration. And if you want to know a little bit more about this, I did a one of my arbitration boot camp sessions was about the case management services that arbitrators can provide. Many arbitrators can provide some structure at the outset if there's nothing in the arbitration agreement about a selection of rules, or if the parties have not agreed upon the rules, by providing a very detailed and standardized procedural order number one. And I'll give to you in your resources a link to Bill Horton's website, which contains a great example of a detailed procedural order number one. And what that procedural order number one does is it sets out the process from beginning to end. And Bill circulates that procedural order number one to parties before the first procedural case conference, which allows parties to consider it, talk to one another, and then they are prepared to have a discussion about a specific process when they attend the first procedural meeting. And that procedural order takes the parties from pleadings, if they haven't yet already been exchanged, through to the exchange of evidence, whether it be in documents and how that is done, or witness statements, through to what the procedure in the hearing will look like, and many times through to the date of the hearing. It is not uncommon that parties will choose the date of the final hearing at the first procedural conference, because that allows for the scheduling of all the matters in between. So if you're involved in an ad hoc arbitration, it's still possible to have the kind of process that you can get in the rules if you choose an arbitrator or ask for a first procedural order that contains that kind of detail. So again, this kind of flexibility can be converted into a structure that gives people a sense of process, what they know what it's going to look like, which is another reason why this idea is that these two kind of processes flow from one into the other. And I think it should give you a sense that there are lots of options for parties and counsel, depending upon what their dispute looks like or what they anticipate the dispute look like when they're drafting their business contract. So parties can choose their own rules, either in their agreement or after the dispute arises. And there are some great Canadian rules and institutions. I've talked about ADRIC and VANIAC, or they can use the UNCITRAL arbitration rules, which are ad hoc rules that can be used in an international arbitration, and they read very much like the model law in many ways. And there are also soft law guidance principles that can help if parties haven't chosen specific rules, or if they've chosen specific rules that don't lead to specific processes with respect to evidence, say. So a good example is the IBA guidelines of the taking of evidence in international arbitration. And don't let the fact that the title refers to international arbitration fool you or deter you, because these guidelines are used very often in domestic arbitration. What's great about them is they set out a process for the exchange of documents, which is not like the exchange of documents in litigation. It refers to reliance documents, that a party will produce only the documents that that party relies upon, with an opportunity of the other party to request additional information or documents. And one of the great parts of this rule, these guidelines, is it talks about experts and the kinds of ways to get expert evidence before the tribunal, including what we call hot tubbing. So the IBA guidelines on the taking of evidence in international arbitration is a great resource. And if the parties have not actually chosen rules or a process, this may be something that the arbitrator decides to order, again, in order to impose some structure on the process. And another benefit of ad hoc arbitration is that the parties can choose their own arbitrator, which, let's face it, is the most significant reason that parties choose arbitration, second only to their wish to avoid the delays in court proceedings. And so the flexibility arises from the fact that the choice of arbitrator is not limited to a roster of arbitrators that is associated with an institution, for example. Many times parties and counsel will look at the list of rosters and not know any of them, or worse, know some of them and hope that they won't be obliged to have them appointed. And because of the opportunity for parties to object to lists of arbitrators proposed by an institution for the purposes of making the appointment. That's not really an issue, but if the list, the roster list is very small, it means that you don't often get somebody that you have full confidence in. And so the idea of the flexibility to appoint an arbitrator is not something that should be underestimated. And again, ad hoc arbitration provides that complete flexibility. Now, on the other hand, you want rules that allow for the appointment if the parties can't agree. If parties want rules but not agree to administration, again, some rules will provide for that. And again, both parties will have to agree. Some rules allow for opt-ins of certain of the provisions in the rules and not others. For example, ADRIC, you can opt out of administration, in fact, and still use the rules. The parties also are not bound by the definitions and, the deadlines found in institutional rules if they want to adopt the rules with some modifications or ask the arbitrator to impose changes to those deadlines. The other thing is parties can decide if they want appeal rights. Under international law, we know that the model law prohibits appeals, and we know that for the most part in domestic arbitration appeals, legislation appeals are permitted unless the parties contract out of that. And that contracting out can be a very important part of the decision-making that parties will make. There are some rules, for example, the VANIAC domestic rules, which provide for the appointment of a domestic tribunal, of an appeal tribunal, which avoids an appeal going to the courts, and that may be very attractive for some parties. So in ad hoc arbitration, party autonomy is limited only by this law of the seat and the law of the arbitration. Again, this goes back to the flexibility. The costs, of course, are lower in ad hoc proceedings because you're not paying an additional cost for administration, which can be quite significant, as I'll indicate in a moment. And not only that, if the parties or the arbitrator chooses a process that is actually quite lean, that can mean that the fees of the arbitrator and the cost of the arbitration as a whole can be quite significantly reduced than if, for example, just a regular set of rules that have very detailed provisions is used, for example. So customization, which is permitted under ad hoc arbitration, can actually lead to a faster, less expensive process, particularly if there's one arbitrator. Some parties, on the other hand, take comfort in the reputation of the institution, but so long as the arbitrator perhaps has a reputation, or there should be no concerns about flexibility of enforceability of the award, for example. So you can see that there are a number of reasons why parties or counsel may want the comfort of the involvement of an institution. Institutional arbitration, how does it differ? Again, it's associated with sets of rules, and those can be very different among them. So you may decide that a certain set of rules fits more neatly with the kind of dispute that has arisen or which you expect to arise. And the important thing is that there is choice if you decide that institutional arbitration is where you want to go, because the rules differ very significantly. And I am going to talk about some of them, but I should caution you that I am not a computer with knowledge about every single rule. So if you ask me a question about some of the rules, I most certainly will not be able to answer it if it's detailed. But what I'm going to talk about is generally some of the differences. Again, institutional arbitration can be helpful where the parties come from different legal cultures in order to create a common expectation. And this is particularly the case where you have a party or counsel from one from the common law jurisdiction, one from a civil law jurisdiction, because the process, the expectations of the role of counsel and the arbitrator are quite different. And in order to ensure that everybody has confidence in the process, an institution can provide for that. And the certainty is very helpful. I think that parties must understand that the costs of an institution can be significant and can vary depending upon the institution. And this will no doubt factor into decisions that are made about whether or what institutions should be used. For example, in the ICC, the costs depend upon, so these are the costs of the arbitration of administration of the institution depend upon the amount in dispute. So if the value is up to $50,000, for example, the costs of administration are $5,000. And then, for example, a case between $1 million and $2 million, the percentage, the administration charges a percentage of the value. And so as the case goes up, case value goes up, so does the fee. And this can end up being quite a significant cost. Of course, on the other hand, you get significant services. Do you want all of those services? The arbitrator's fees then are on top of the administration fee. And again, the ADRIC ICC provides guidance on that. And for a dispute valued up to $50,000, the fee is $3,000. So for a dispute up to $50,000, you're paying $8,000 in administration and arbitrator fees, which may or may not make sense. But obviously, the proportion of the fees and the administration costs and the value of them, the numerical value, will increase as the value of the dispute increases. So if you compare that, for example, to the administration costs of some of the other, so for example, for the ICC, a dispute of $1 million to $2 million, the value of the fee that will be imposed is between 0.7% and 3.6% of the total value of the claim. If we go to the admin costs for example, ADRIC, it's $6,000 for a $5 million dispute. For the LCIA administration, it's 220 pounds per hour that the administration takes. And then, for example, VANIAC, there's a commencement fee of up to $20,000 for a dispute valued at over $1 million. And I think this is the international rules. And admin fee on top of that of $650, all of which is payable per quarter per party. So it shows you the wide variety of fees that can be charged. And again, you want to go directly to the schedules that talk about those fees before you make any specific decisions. There are percentages for expedited procedures as well. And the ICC court, for example, has the full discretion as to fees. And that will sometimes depend upon such things as whether the arbitrator was efficient in how the arbitration was run. There's so much more process in some of the administration and the institutional rules by the institutions. That is also a significant factor to consider. With all of this extra process and administration, what does that do to increase the timeline? So, for example, I've talked about scrutiny of the award. That can take time, a few months sometimes. So even after the arbitrator has made or finalized the award, it's then got to go to that extra step. And so what you're getting is some comfort about the enforceability of the award, but in exchange for that, you're perhaps losing a couple of months. One of the real values of institutions, however, is that they are often on the cutting edge of best practices. And this is partly because of the administration. They invest a lot in the process, educating their arbitrators and counsel about the processes and making sure, as I said, that they're cutting edge. So, for example, there may be security issues that are particularly important in sensitive cases. So everybody's talking about cyber breaches. Well, some of the institutions have long addressed that issue and required arbitrators to address that issue with the parties head at the very beginning, in the first procedural meeting. So the LCIA, for example, has a data protection rule. The ICDR requires cybersecurity and data protection and privacy issues to be raised with the parties, and provides protocols and processes for dealing with cybersecurity breaches, etc., and draft model orders. So if the purpose of the arbitration is in part to maintain confidentiality, and there are risks, for example, when one of the party or both of the parties are high profile, states, for example, and the issues are particularly sensitive, there may be real risks of hackers and data breaches, which the parties will want to address. And that may include discussing hiring third-party experts and consultants to ensure that the data is protected to the greatest extent possible, and ensuring that all of the participants in the arbitration are following best practices. So there are protocols out there that are published by the institutions in particular that provide for that. And what that means is not only is the process cutting edge, but that the arbitrators themselves are up to date on what best practices are for ensuring that some of these cutting edge issues are dealt with up front. There may also be portals offered for the exchanges of information, again, to protect confidentiality, but also to facilitate the administration, which the institution will do, much of which requires the institution to have copies of the relevant documents. There is also the benefit that some institutions provide of essentially monitoring arbitrator conduct. So the institutions have control over who is appointed, and if there is an arbitrator who is not meeting standard by, for example, delaying significantly the issuance of an award, or there are complaints made about that arbitrator, the institution may not appoint that arbitrator again. And that's the kind of control that you don't get from an ad hoc arbitration, where your recourse is really to challenge the arbitrator either under the rules or before the court, if, for example, the arbitrator has failed to do his or her duty. There are other questions to consider. Again, autonomy. Some counsel and parties want complete autonomy, and that would mean an ad hoc arbitration would be most preferable. And if you can adopt some procedures from institutions, all the better, because you do have choice, but then you have structure. ADRIC is a good example of that. And then those rules will also deal with conflicts between rules and relevant legislation, you hope, something you'll want to consider if you're picking and choosing among various provisions in rules. Costs and speed. I've already talked about this, but the greater flexibility in ad hoc arbitration, time and time again, shows that on average, there is less cost and a speedier result if the advantages of the case management in arbitration are utilized. But the choice of arbitrator is important, of course. You've got to get an arbitrator that buys into that process. And if, for example, the parties choose simply to adopt the rules of civil proceeding in their arbitration, the benefits of arbitration and case management will be lost. But an ad hoc arbitration really does allow the parties and the arbitrator to control not only the process, but the speed. The speed may also be determined by the rules. So if you are going to adopt certain rules and speed is important, this is another issue to address. The ICC requires an award 6 months from the date of the receipt of the file. Similarly, ADRIC is 60 days. ICDR is 60 days from the closing of the hearing. VANIAC is 90 days from the latter day of closing of the hearing or receipt of written submissions. And then, of course, there is the issue about if the arbitrator needs an extension of time, who may grant it? Is it necessary to go to the court, or does the tribunal have the authority, the jurisdiction, the discretion to make to extend the time? Because, of course, you can never guarantee that a court will grant an extension of time if it's sought. There's also the issue of whether the rules specifically provide for a summary judgment or summary disposition type process, which is another process that can be used to increase cost and speed. The VANIAC and ICDR rules specifically, this is the international rule, specifically provide for summary disposition. And sometimes there is a dispute where other rules don't provide for that process about whether it is permitted. So if that's something that's important to you, you'll want to take a look at that. Confidentiality is another important consideration. There is an assumption that arbitration is confidential. In fact, it is private. And it is confidential only if there's an agreement of the parties an order of the arbitrator, or the rules provide for confidentiality. And we see that in the ADRIC rules, for example, the LCIA, the ICDR, the VANIAC rules, and confidentiality applies in the ICC rules if the tribunal orders it. So another issue, if you're looking at an ad hoc arbitration without rules and confidentiality is important, you want to ensure that goes into the arbitration agreement, or and hope that you can convince the other party that it's important or satisfy the tribunal to make an order. So how much procedure do you want, and does the case merit? Again, some rules are more detailed. The UNCITRAL and ADRIC rules have a complete code of process from beginning to end. Likewise, the IBA guidelines on the taking of evidence in international arbitration. Some are more general. For example, the ICDR, the LCIA, and the VANIAC rules have no specific document production rules. So that's a place where the parties can either reach an agreement or the tribunal can make an order. The VANIAC rules have rules relating to virtual hearings. And while at this stage, since COVID, there's no dispute anymore that a hearing can take place virtually, there are a lot of protocols floating around which facilitate virtual hearings and ensure that all of the various issues and problems that may arise are addressed. Those protocols are very useful. But the VANIAC rule also talks about virtual hearings. Maybe that's important in your process. Regardless of what rules are used, there are common principles, which is that the arbitration must be conducted in the most efficient, least cost-effective manner, and the arbitrator ultimately has control over the procedure. I've talked about the appointment of the arbitrator being important when you're considering rules. How much control you have over the appointment and who that person might be. The challenge of the arbitrator for bias, certainly not the most important thing that you will think about when you're choosing an arbitrator, but the rules relating to challenges for bias can be quite different. So first is, who is the challenge made to? In some cases, it's made to the tribunal itself. In some cases, it's made to the tribunal, to the institution, with or without notice to the arbitrator. And so that is important. The timing, when the challenge for bias must be made, is different in the various rules. And those rules will invariably say that if you fail to make an objection within a specific period of time of learning of the grounds for objection, you will have waived your right to objection. But the rules do not provide for a standard time frame or the process. Emergency arbitrator. This is becoming increasingly important. The rules a few decades ago did not provide for an emergency arbitrator at all. And so there was no option where people needed what we call injunctive relief in the courts for getting that kind of relief in a confidential way before an arbitrator. And the parties in such a situation would have to go to the court, where invariably a significant amount of evidence would have to be adduced, which would essentially eliminate the party's interest in confidentiality. There are now a variety of approaches for the appointment of an emergency arbitrator, sometimes ex parte relief, sometimes not. And sometimes there is a process for getting an accelerated appointment of the tribunal. And the significance of that, of course, is the emergency arbitrator has the jurisdiction to make an interim order, which can be changed by the tribunal once it's appointed. An accelerated appointment of a tribunal means that the tribunal that's going to hear the merits of the dispute makes the interim measures decision. And there's sometimes an opportunity for an application for emergency preliminary order along with an interim measures application, which is essentially a request for an order that the status quo be preserved before the interim measures application is brought. And that's a feature of the VANIAC domestic rules. So if there is urgency, which you anticipate will come up, there are a lot of approaches in a lot of rules which allow for this kind of relief to be sought, but you need to carefully read the rules because it's very different. There is an expedited procedure many times in the rules, particularly for cases which don't merit the full process, often where the matter is of small value. So the ICC refers to a small value dispute as between $2 and $3 million. The ICDR has a $500,000 threshold, but written submissions only are permitted if it's less than $100,000. And under the VANIAC domestic rules, there is a documents only process for disputes valued at less than $250,000. Huge variation. Again, what do the rules say, and what do the rules can be done to work for you? The VANIAC rules, for example, have a flat fee for small issues. You'll want to make inquiries into that, and that's a flat arbitrator fee. Most of the rules provide for joinder and consolidation, which of course is very helpful. Of course, doesn't apply where third parties are affected. I've talked about appeals. Some rules provide for an appeal panel, some do not. And there are other issues that can arise where institutional rules are selected or institutional administration is selected that should be considered. Is the award delayed because of scrutiny or otherwise? The fact that many rules provide for a specific time limit within which the award should be delivered provides a lot of comfort for parties who undoubtedly simply want a decision made. And the arbitrator who agrees to take on an appointment where this time limit is short is essentially promising to deliver that award within that time frame. Another unanticipated, and thankfully rare issue that institutions can assist with is the problem arbitrator. Where there is a tribunal and there is one member of the tribunal that is not acting in a way that the other tribunal members think represents, is consistent with their duty. So, for example, when there are intra-tribunal issues, they are issues that for the chair to resolve. Sometimes they're personality issues, sometimes they're conflict issues. But if they go deeper than that and the chair can't resolve them, the chair is really it's really hamstrung because the tribunal must meet together. So the chair can't take either of the other arbitrators aside. It must be dealt with together. And that's where institutions can provide assistance to chairs. And in some cases, the institutions will actually remove an arbitrator. But I do know instances of arbitrators who have had that situation arise and have had comfort from the fact that institutions can provide more assistance in dealing with those kinds of situations than our ad hoc arbitrations. Again, I doubt this will be something that people will consider when they're looking at appointment. So what are the takeaways? A good arbitration clause can often prevent problems down the road. The choice of rules and whether the arbitration should be administered or not is a very helpful way to start if the parties can agree on it, and particularly if they have a sense of what the dispute is going to look like at the end of the day, and whether it's going to be urgent or not. Considerations may be different in international and domestic arbitrations, of course, so reading the rules is absolutely essential. Get advice from somebody who has actually used the rules or had an arbitration with the institution, because the rules and the promises made by the institution may be not what counsel are experiencing on the ground. So if the question is, what kind of service does this institution really provide? It's useful to talk to counsel who have actually used those rules, and they can give you some pointers on how to use them and what considerations should be given if you're making a choice. That is not something you can often see in the marketing material in the institution website. However, taking a look at that website is extremely important too. Are there additional toolkits and resources for counsel? You often see that very commonly in institutional arbitration. For example, I think it's the ICDR, it might be the ICC that has a whole how to case manage an arbitration section of its website. Certainly open to other counsel not using their rules to use, but you get a sense of the kind of investment that institutions are making to try to facilitate and provide a product that is useful to its users. So that's all I have to say about the choices between institutional and ad hoc arbitration. I don't have any questions in the Q&A box, but I'm going to tell you a little bit about what to expect in the next 2 sessions. So I'll give people an opportunity to put something in the Q&A box while I'm talking, and if I don't see anything, then we'll close. So the next 2 sessions are going to be focused on Med-Arb, or as some people stridently call it, Med-Arb, and I kind of get their argument. Med-Arbs are often discussed, but there are a few practitioners that have a lot of experience in it or really know very much about it. And the exception to that is family law practitioners, which use this process frequently. But commercial litigation counsel, commercial arbitration counsel and arbitrators rarely use it. And the reason for that is there are a number of pitfalls. And so you have to really know what you're doing. And in order to not jeopardize the fairness of the process. There are traps for the inexperienced. How do you ensure that the arbitrator, mediator's independence and our impartiality are maintained? What role does the arbitrator or mediator play in the mediation when the ultimate decision maker is the same person? Does that mean no evaluative mediations? What information that is obtained in the mediation can later be used in the arbitration? How do you ensure the clear divide between arbitration and the process and the mediation process so that all participants understand it? Right now we're in the mediation process. Right now we're in the arbitration process, and what will actually happen is different. What if one party wants to bail partway through? What about ARB, Med, ARB processes or Med, ARB, Med processes? In other words, how creative can you be where the situation demands it? So for example, what happens if the parties want to look at their dispute on an issue by issue basis? And so you're independently arbitrating and mediating each issue. What does the process look like for that? Because you've obviously increased the complexity. And is there a specific kind of case that calls out for this kind of a process? So at my next session on March the 21st, I'm going to be talking about some of those issues for a Med-Arb process in general. And then part 2 will be on April 18th, and we're going to have a little bit of a change in process because I've invited David McCutcheon, a very well-known and respected practitioner who does a lot of Med-Arbs, and I'm going to essentially interview him about this process. He's going to tell us his experience about some of the challenges and the ways to avoid disappointed parties or the potential that an award will be set aside. And I will be preparing some questions in advance. If you're interested in this session and you want to send me some questions in advance by email, I'd be glad to put them to him. I will, of course, have a Q&A box open during that session as well, and you'll have an opportunity to ask questions of him. So I don't see any questions in the Q&A box. So thanks very much for joining me, and have a great day. I'll see you next time on March the 21st. Bye.